Welcome to another episode of Case of Interest Kohberger. I'm Newswatch 16's Stacey Lang. Last we spoke, Kohberger and his defense team and all of the Latah County prosecutors were in court for what turned out to be a 2.5-day long hearing discussing a series of motions presented by the defense that had to do with evidence in the case. We now have decisions for all of those motions. The judge issued those decisions last week. We've taken some time to provide some analysis of what really this all means. Because on paper, it looks like the Kohberger defense team was issued a series of losses, and they were. All of the motions that they presented at that hearing in January were denied. But we spoke to a defense attorney that kind of explains how this is part of the long game when it comes to the defense in preparation for an appeal, which is almost certainly going to happen if Brian Kohberger is convicted of the 4 murders at the University of Idaho, because it's a death penalty case, and death penalty cases are almost essentially an automatic appeal. So this kind of is laying groundwork for an appeal, not necessarily the trial, which is set for August 11th in Boise, Idaho. Let's go through those motions, and then we'll provide some analysis of what really those decisions mean. The defense asked for what's called a Franks hearing, which basically alleges that evidence was collected against the defendant surreptitiously, that police either lied or misrepresented the facts in order to get search warrants. That is what was alleged by Brian Kohberger's defense team. The judge denied the possibility of having a Franks hearing, saying that there wasn't enough evidence to prove those allegations, or at least that a hearing was warranted to further look into those allegations. They asked to have evidence collected from Brian Kohberger's cell phone excluded from the trial. That was denied. That paves the way for prosecutors to admit that evidence at trial. They asked for the arrest warrant for his arrest in Pennsylvania to not be admitted at trial because it was, forget the exact words, but the defense team said that his Miranda rights were not read and it was improperly done. The judge denied that, saying that the knock and announce requirement that police have when they're issuing an arrest warrant was not warranted in this case. The investigative genetic genealogy, a huge part of the prosecution's case, the defense asked for it to be thrown out. That was denied. That will be allowed at trial. You can read through, if you did not get to see that hearing, which was on January 23rd. You can now, if you go on to the Idaho Court's Case of Interest page, and we'll include a link in the description, you can go and read the transcript of that hearing if you're interested. You can also read through all of these denied motions and see some of the legal theory behind it. To get that legal theory and kind of help us wrap our head around this mass of court documents that came out last week, we spoke to Brett Riegel, a defense attorney from Monroe County, from ARM Lawyers. Let's hear what he has to say. So we're joined by Brett Riegel, a defense attorney who has lent his analysis to the Brian Kohberger case several times. We're now several years into this and rapidly approaching a trial that is set for August in Idaho. And this has been the biggest day in court in many months, I think, with these major decisions coming down from the judge. First question I want to ask you, Brett, is what kind of strategy, as a defense attorney yourself, what kind of strategy do you see Kohberger's defense laying here?
Well, obviously, this is a case that has received incredible scrutiny from minute number one because it's a multiple homicide. It involved lots of CSI-style investigation. It involved multiple states, a manhunt, etc. So it's and by manhunt, I mean that they, chased him down in Pennsylvania, which is what brings it to us. Not that it wouldn't be a case of national interest anyway, but that it's even more of a case of national interest and local interest because he was from here. So they're really trying to make sure that they raise every issue that they can that is at least colorable, so that as the law may change, they may be able to take advantage of that, or they may even be able to create the law on a particular given issue. It's kind of important to remember that the way that the legal system is designed, if you don't raise an issue, you've lost it. So you can't come back and say later, oh, I should have said whatever the issue may be. And so they're trying to put everything out there that they can. They've raised every potential suppression issue. And in some instances, it may be that as the law develops, they'll get relief, particularly as it relates to the digital discovery, because the privacy interests are being re-examined. It's always important to remember that the law is usually about a mile behind science and technology. And so they're trying to extrapolate off of the way that we had set precedent before into what is now an available technology that really changes things. And you see the courts do this, routinely as circumstance outstrips the status of the law. Just a quick example, the United States Supreme Court a couple summers ago decided the Bruin case, which is a really big deal for firearms rights. Now we're having litigation over the question of whether having a firearm in your car is akin to a person in the 1700s having a firearm in the saddlebags of their horse. So the court has to do an analysis of, well, what is that most like when this decision was made? And then also, should we even change the law? Should we view it as, in today's society, people would expect a level of protection for something that didn't exist years ago?
You kind of touched on this also, but especially since we're looking at a death penalty case,
yes,
which are so often wrought with appeals, rightfully so.
Well,
we're setting
there's almost
up,
always an automatic.
Yeah. But are some of these suppression issues laying the groundwork for potential appeals down the line?
Oh, absolutely. If you don't raise the issue and create the record, you then don't have that item to take up to the next level. And realistically here, because they've raised things that are an analysis under both federal and state law, there will potentially be two levels of appeals, because they can go through the state court system in Idaho, and even if there is no relief, they can then pursue it in federal court to see whether there's an analysis by the federal court system that goes a different way.
And correct me if I'm wrong, but my understanding is that the case law is talking specifically about the genetic genealogy suppression.
The IgG.
Yeah, IgG. That the case law is pretty strong, that the Pennsylvania State Police collecting DNA from discarded trash outside the Kohberger home, that's okay. The argument that Kohberger's defense made was that it wasn't his DNA, it was a relative's DNA. Do you see that as something maybe, even a decade down the line becoming an issue? Because we have,
I think
everyone has a family member who has submitted DNA to 23andMe or Ancestry.com.
Yeah, I think that is a spot where there will be a lot of developing law, because the question becomes, what privacy interests do I have in my DNA compared to the members of my family who may have chosen to give theirs up? Do I have a higher expectation of privacy that society would recognize because I've never chosen to participate in Ancestry or 23andMe or what have you? And I don't know what the outcome of that will be. Obviously, it's a great issue to argue about, because, again, these were things that we didn't have years ago. Maybe you borrowed your mom's phone, and now the question is there an expectation of privacy in the utilization of mom's phone and the data that would be on there, different from like what realistically could I expect my privacy interest was in that data? I don't know where the court will end up going, but it's a really interesting thing, because the science has progressed. We have investigative tools that were, a dream 30 years ago.
Right. And data privacy, actually, you kind of led us into that, is another one of these issues.
Yes.
it's in the decision that has to do with suppression of his phone data, of Kohberger's phone data. The judge talks about third-party disclosure, which I had to Google. I was not familiar with it. I'm sure you are, but I think a lot of our viewers might necessarily know that a lot of our data is not at all private. And there's no expectation.
So the first question, right, the first question that you have to answer is the question of to whom are you disclosing data and for what purpose? So, for example, if you're sending a text message to your lawyer or to your priest or to your spouse, there is probably a level of privilege that protects that particular communication, even though it is to a third party. But when you're sharing it with Amazon or Google or Apple Pay or whomever it may be, that's a different issue. And the court wisely went to all of the policies that they produce, those 3-page long user agreements that you just fly through and click at the end. Well, there's language in there that addresses what they're going to do with your data. The court looked to some of that, as well as the sort of general expectation that somebody has when they share information. And what the court analyzed is that because Kohberger was active in the exchange of information, it wasn't merely a passive. He didn't just have his phone on and they were tracking the movements or something of that nature, but rather that he was interacting with the websites and providing the information. The court really didn't have any problem reaching the conclusion that it was not protected. It didn't have a reasonable expectation of privacy.
What do these decisions mean to the prosecution now going forward?
Really what they mean is that the prosecution will be able to enter evidence that they otherwise could have had excluded. It prevents what's called an interlocutory appeal. Normally what happens in a criminal case is that you don't appeal anything until the case is over. So theoretically, what could happen here is that all these motions have been denied. They could go to trial. Kohberger could be acquitted. If he's acquitted, there's no appeal. Nobody gets to review whether the judge made the right decision or not. If the judge had suppressed some or all or pieces of the evidence, then the state, or if it were in Pennsylvania, the Commonwealth, would have the right to take an interlocutory appeal, meaning an appeal in the middle of the case, saying to the next level, hey, we think the judge made a mistake. It's going to hamstring the prosecution. If he is acquitted after trial, we don't get the chance to have this reviewed. We need to have it reviewed now so that a determination can be made of whether or not we can use that evidence in front of a jury.
And we don't have a crystal ball, but as we're watching this progress, do you think a trial happens in August?
Very difficult to say, and the reason that I say that is a number of things. There will certainly be more litigation between now and the time that trial would happen. At the very least, usually right before trial, there are a series of motions in limine, which are motions to limit evidence or motions to preclude the use of certain things or to allow certain testimony. You try to get a ruling ahead of time so that you're not surprised by the outcome when you're actually in trial itself. But here, because it's a death penalty case, because there will be 2 phases to it, guilt and then penalty, it's very easy to have things go sideways and end up taking more time than expected, as well as all of the calendars of the people that will be critical witnesses. I mean, I don't know how many expert witnesses there will be in a case that has played out the way this one has, but my guess is more than a handful. Yeah. And that means that you are utilizing the schedules of, let's say 2 lawyers on the prosecution team, 2 lawyers on the defense team, a handful of police officers, experts. You may easily have the court 30 different schedules that are influencing when the case can be tried properly. So anybody's guess. I mean, we're sitting here in February, so August would seem a very reasonable time since the most important pretrial litigation has been concluded, but there's no real way to tell if that's going to happen or not happen. And then the biggest issue becomes one of 12 people who are prepared to indicate truthfully that they don't have an opinion on this case.
There's a lot to talk about, and we appreciate you always taking the time to break it down for us. Thank you so much, Brett. Again, that was Brett Riegel, a defense attorney from Monroe County, lending his take on the progress in the Brian Kohberger case so far. One other little thing to talk about, just at the beginning of this week, the judge approved a request from Kohberger's defense to add an additional attorney to his defense team. So we'll see what that has to bring as we progress towards trial, again scheduled for August. We'll see what happens, but we'll be with you every step of the way. Thanks for watching another episode of Case of Interest.